So tonight, the Karnataka public's question is this, viewer. Will there be any consequences for Justice S. Vishwajit Shetty, the judge whose order let Darshan roam the world while accused of savage murder? Or is judicial accountability still the one VIP privilege nobody dares to touch? Deepak Bopana is live with me. He's tracked this story very, very closely since last year. Deepak, after 288 days on bail, where he's managed to travel abroad, live life king size, shoot for his films, pursue his dreams, he's finally back in jail now.
Well, absolutely, Shiv. And more importantly, what this order of the Supreme Court has done is not just repose faith in the judiciary for the family of Renuka Swami, but the families and people across the country who are fighting the high and mighty. Today they have hope that, well, yes, we can trust the law of the land, we can trust the judiciary to do justice, whoever it may be, however powerful they may be. And some of the, observations earlier and today, what the order that was dictated and the judgment copy that's with us is a clear indicator of that, where they say that this is an individual who managed to subvert every process. He was inside prison, held a cigarette in his hand, held a cup of coffee, sat there along with his aides, and as if it was a round table conference, or he was sitting in a park and enjoying himself. Just imagine what the wife of Renuka Swami would have felt, what the mother and the father would have felt. Now, this is a man who was supposed to be in prison, pay the price for murder, but he was enjoying his life there. Not just that, after that, he claims that he has a, back injury, he needs surgery, he goes, gets medical bail on medical grounds, doesn't get a surgery, and then manages to get bail. The Supreme Court has pulled up all of this. Now he is back at Parapanagrana, hopefully this time for good.
Hopefully this time for good, but 288 days on bail would be more than enough time to actually, possibly influence witnesses, turn witnesses hostile in one of the most horrifying crimes of our time. But I want to get a sense of it, because the judiciary is something that nobody can question. The judiciary is an institution that nobody can criticize because of the risks of being held in contempt. The judiciary is a kind of golden goose. You cannot really point a finger at it and cast aspersions on the judiciary. But tonight I really want to ask, who's going to hold the judiciary accountable when something like this happens? And remember, it is the Supreme Court that has had very, very adverse comments on the bail order given by Justice Vishwajit Shetty of the Karnataka High Court. Joining me live for a perspective on this, Aniket Nikam, advocate with the Bombay High Court and Supreme Court. I'd like to start with Dr. Ranjana Kumari, who is a well-known activist. She's director of CSR and chairperson of Women Power Connect, or WPC. Dr. Ranjana, I want to come to you first. You've seen what the Supreme Court has said about this bail order. It's unconscionable. It says, something like this should never have happened, basically in plain speak, that, this has been a completely incorrect, application of the law in the granting of bail to a person who could easily influence witnesses and do whatnot while out on bail. Well, he's been out on bail for 288 days and he's back in jail now. What do you think, Dr. Ranjana?
I think this is a very sorry state of affairs, and such criminals who have, been let out, and we have seen that there are three things that happens when they are out, and why they are out is because their bail is not defended well by the police. They are supposed to be putting all kinds of arguments against giving such bail in the court, but they don't really do that under whatever consideration, I don't know. But most important thing is that one, that not only that they will be able to influence the witness, and they will be able to, also scare people. They can even buy people off. There are all possibilities when such criminals are out of jail. And also someone who's come from the background which is affluent, which is, also popular and well known. So I think this is one possibility. Second possibility, also threatening the family. That always happens, and crime, and then also bullying and threatening the family, so the family can back out or maybe lead for some kind of a compromise and things like that. It's a murder. It's not just any kind of, small minor crime. It's the the highest crime. And third, which is very, very important, is that in this kind of a murder, if we are sending a social message to society, courts do not realize that what do they do in their whatever, I don't know whether, I mean, in their ignorance, or are they are not able to see through these things, but they are sending a message to society that, look, even if you commit such a severe and grave crime, you can be released
Yeah.
and you can be having your normal life. And we have seen time and again happening, and this case especially court should have been very, very careful, because they should know that this someone is of influence, someone who's been, kind of
Correct.
just. So I think this is very important. I absolutely disagree. I condemn such a thing. But well, again, as you rightly said, Shiv, that these are the courts of India. These are all kinds of weird things happen, and especially crime against women. When something like this happens, then courts become always a little bit more. I don't
And the
want to
point
charge
is,
the
in the
courts.
public eye, Dr. Ranjana, is that these weird things should not be happening in any court, and least of all the High Court. So as a citizen, I also want to bring in Aniket, Nikam on this question, and it's not a loaded question. I'm genuinely curious, Aniket. In this case, it is the Supreme Court that has called out the High Court, overturned that bail order and said, the bail order was riddled with serious legal, infirmities. Amounted to a mechanical exercise of discretion. Bail was given without special or cogent reasons, selective application, many such harsh words. The public will be wondering, after 288 days on bail, will there be any accountability at all for the judge who actually gave this bail to Darshan? People will be curious about questions like that. Aniket.
Well, Shiv, let me first tell you that grant or denial of bail falls within the domain of discretion of that particular judge. In our country, the law has been that bail is the rule, jail is an exception. However, in exceptional cases which reflect extreme cruelty in terms of the manner in which the offense has been committed, the magnitude of the offense, the courts have been extremely circumspect in granting bails in such matters. There have been umpteen number of cases where bail was granted by Sessions Court, but it has been cancelled by High Court. There have been umpteen number of examples where bail is granted by High Court, but the Supreme Court has eventually cancelled that bail because the order passing bail was, in that sense, did not consider the entire material on record. It was an order based on perversity, and therefore there have been cases and instances where the Supreme Court has cancelled the bail. So as far as your question of fixing the accountability is concerned, well, since it is the discretion of the concerned judge, at that point in time, probably the court must have thought that they should grant the bail. However, that is why we have the three-tier legal system.
Yes.
From Sessions, you travel to High Court, from High Court to Supreme Court. So if there is a mistake in that sense in passing orders, the superior courts rectify it by passing appropriate orders. Now, in cases like this, where the offense was a deserted one, there was extreme cruelty, brutality, and there was enough amount of evidence available on record. Despite that, if the court grants bail, then this is what the Supreme Court do, which is cancel that bail, because the primary consideration in matters like this is prima facie establishment of the case. If prima facie it is seen that the accused has committed the offense, the courts would, as I said earlier, would not normally grant bail unless it's a case of prolonged incarceration, where a man is incarcerated for 8-10 years and trial has not progressed at all. In such circumstances, even the Supreme Court has said that Article 21, which is right to life, gets violated even of the accused. But this is not that case. Therefore, I believe that rightly, wrongly, the Honorable High Court.
You're right. It is discretion technically. This man, Darshan, was in jail for 141 days, Dr. Ranjana, before he was granted bail for roughly double that period. 144 days in jail, 288 days on bail. Incredible. Before he is packed off back to jail. But in the public eye, this will not be seen as discretion at all. These are all technical, fancy words that, that the judiciary has. But at the end of the day, this will be seen as a VIP privilege to someone who is influential. And it is happening so shamefully and shockingly at the High Court level. Because say what you like, Dr. Ranjana, in the public eye, you expect such things perhaps to happen at the trial court level. Most definitely not at the High Court level.
Yes, I think this is something which is not only shocking. It is really something which is the in when the 2004 the 24 when the case happened, it really shook the conscience of the whole industry, the film industry, and also that everybody was so much so much worried and so much shocked. But when it happens, like you are hardly in jail, then what is the message? Message is law is not, first of all, law is not the same for everybody. If you are high and mighty, you can get away with that. I mean, half the time in jail and most of the time outside. So, what kind of a thing is this? And High Court getting influenced like that or getting coming with this kind of a judgment certainly is not expected at all. It is really something, and also Supreme Court has to not every time walk in and say that put the criminal behind the bar again. It is High Court's discretion to do that. Is they are supposed to do that. If it is so long that the personship is out, then means what? Means that you don't consider. And this case, when he was sent to jail, there has to be prima facie evidence for against which he has been sent to jail. And now only that all those evidences have to be presented in the court so that he can get the punishment that he deserves to get the punishment.
Yeah.
But when you let him out, then certainly you are giving him chance to manipulate it, to bring it, and is manipulation enough that you are sending him out of the jail for so long, and then you are again giving the chance for him to go and manipulate,
And
to
during that time, he also
manage,
got to travel
as we say in
abroad.
our system, Shiv. We say,
During
no, they manage things. Now, if it is managed for these people, then why the law is, what kind of a legal system are we living in?
I completely agree with that. Aniket, I'm not sure what can and cannot be said, about the reasons for bail. But, the circumstances, again, I say this as a journalist. Pictures of Darshan, inside jail, clearly living with a certain degree of privilege, being able to have cigarettes and drinks out in the yard, access to his lawyers, much more than perhaps other inmates. The extreme nature of the crime that he was actually accused of with a reasonable degree of evidence. This is, of course, a case that is under trial. All of these adding up shows that the Supreme Court is absolutely right when it says that, bail was given without special or cogent reasons. What I'm trying to say is one doesn't need to be a lawyer, to feel exactly what the Supreme Court has basically put into words today.
100% Shiv. What the Supreme Court has said is absolutely correct, and this has been the law of our country. That in a case where the offence is prima facie seen to have been committed in a matter like murder, normally the court should be extremely slow in granting bail unless there are other circumstances like prolonged incarceration or other grounds, parity, so on and so forth. But in matter like this, which is a clean and clear case of a grave murder, the Honorable High Court should not have exceeded its jurisdiction in granting the bail. But now, today, I wouldn't say that one example or one instance would define the judiciary of our country. This order was passed. I would say it was a perverse order, and therefore the Honorable Supreme Court has cancelled it, had set it aside. And that is what the law of land is, that if the offence is clearly spelled out, if it is an offence of as grave as murder, the court should not normally grant bail. And that is what the Supreme Court has reiterated.
Dr. Ranjana, at the end of the
Yes.
day, and I'll get final comments from the both of you, that the Indian citizens' sort of jaded view that if you are rich and privileged, you have special access to legal privileges, special accommodations within the law, special mechanical exercise of discretion, in the words of the Supreme Court. These are things you can count on. If you are rich and privileged, you have a massive fan base. And that even if you are charged with a really grisly, ghastly murder and crime, at the end of the day, if you have a reasonable amount of influence, and we know Darshan is a superstar in Kannada cinema, with a vicious fan base that attacks anyone who says anything negative about Darshan, and if you're on social media, you will know what I mean. But then, this just reinforces the age-old suspicion of every Indian that अगर पैसा है, थोड़ा influence है, थोड़ा शक्ति है, then you've got separate laws that apply to you.
Absolutely. I mean, you just said right, spot on, Shiv, that everybody is not equal before the law. If you are someone with influence like him, then you certainly have more privileges inside or outside the jail. It doesn't matter where you are. You get the privileges, everybody is around you, everybody is there to protect you. And when the Supreme Court says that his release can affect the trial and witness tampering, then what is the message to the High Court? That's what I'm just wondering. Now, because in our system, we are not able to really question the court judgments, and we are not able to. So courts can do anything. I mean, courts can come up with any kind of weird, all kinds of statement, judgment. Judges make their own personal comments about so many cases, and this is something which in a country which is democracy, in a country which is rule of law, and in a country where we claim and we believe in everybody equal before the law. What is this message? That's what I'm saying, that if he can tamper with the evidence and he's allowed to tamper with the evidence, then certainly he will get away with it. That's what it is. It could be anybody. Imagine a common man or common woman or somebody on the street has done this kind of crime. Do you think there was any possibility of him or her going out and being at large like this? And highest court of the country had to intervene to say that no, put him behind the bar. They had to threaten him to go. Either you surrender or you will be, punished. So I think this is something which we need to look at. Parliament should do something about these kind of relationship between High Court and Supreme Court, and between the criminals, and the way High Courts are these days behaving, and High Court judges are behaving, we all know. So I think this is something needs to be really reviewed thoroughly. Okay, this may have been British time rule when you can't question anything, but when we are seeing clearly that there is violation of legal protection given to every human being, especially the victim's family, then you are definitely, you have to review this kind of a system, and you have to see what new system can be evolved, which is better, which really promises everybody who's there in the country as a citizen equal before the law. Not that you are high and mighty, you are privileged, you have money, you can do anything.
But that is the reality right now. I have 60 seconds left. Aniket, I'll ask you a personal question. In these times when there is an erosion in public trust in the judiciary and the law, as a young lawyer, how do you interface with that? How do you process that?
Well, Shiv, I have been practicing law for 18 years. I appear daily in high courts and all other courts. And I've seen that one case like this cannot define our judiciary. That's number one. Number two, everybody is bound by constitution. Everybody is equal before the law. Well, high and mighty and rich may be able to engage senior, costly, heavyweight lawyers, but that does not mean law treats them differently. We have seen celebrities getting convicted in our country. So it's not as if law treats them differently.
But there are differences in how they are treated.
No,
look at Ram
there have been instances, as I said earlier, there have been instances where they have treated, where actors or probably this particular accused was given a VIP treatment in the jail. But that does not mean that is happening with everybody or whoever that person is. Now, this is an exception. Exception cannot become a rule, and that is the very reason why the Honorable Supreme Court
I take your point. I take both your points, but the problem is
one exception.
The problem is the exceptions have become very common. Whether it is as Dr. Ranjana said, whether it is Gurmeet Ram Rahim, whether it is Darshan, whether it is there are so many other examples of people who've clearly got a separate law than that which the rest of us are subject to, is something that is reinforced by cases like this. I don't think it is any longer just an exception, but hopefully Darshan will face justice, and we will move towards being a country where one law really applies to every one of us. Aniket, Nikam and Dr. Ranjana Kumari, a pleasure. Thank you very much for being with me here.